Afternoon, sir.
Good afternoon.
We'll see Dr. Martinelli up here. Sir, as you can expect, you do remain under oath, so no need to re-administer it.
Thank you, Your Honor.
And thank you, Mr. Gutierrez.
Thank you, Your Honor. You're welcome. Afternoon, sir.
Good afternoon.
We were talking yesterday, correct, for a little bit
Yes.
about this case. Did you talk to anybody between yesterday and today about this case?
Other than Mr. Martini,
Okay. And what did you discuss with Mr. Martini?
I just talked with him about his testimony and thought he did a good job, from what I could tell.
Anything substantive that you talked about? His conclusions? How would it impact your testimony? Anything like that?
No, sir.
You didn't talk to any of the defense attorneys about your testimony, anticipated testimony?
No, sir.
Did you review any materials or anything last night in preparation for today?
Yes, sir.
What did you review?
Reviewed the report, looked at a diagram, looked at a couple of photographs.
Okay. Sir, I don't know if you remember, but yesterday we kind of left off on the military training aspect of the movement by Officer Brelo. Remember that conversation that we had?
I do.
Okay, and you yesterday refused to acknowledge that there's a difference between civilian and military training. Is that correct?
No, what I said yesterday is that there are some differences between military training and police training, but it depends on what that training is. Some things are similar.
Okay. Sir, would you agree with me that when you're in war, it's different than when you're policing civilian society? Would you agree with that?
Using your definition of that concept, yes.
Okay. Sir, did you review Officer Brelo's statement?
Yes.
And we're talking about, and you talked a lot yesterday about Officer Brelo's perception, correct?
Yes.
And would you agree with me or not that to be able to infer perception, that when the person actually speaks what he's talking about, that would then, in fact, tell you what his perception is? Do you understand what I just said?
Overruled. You may respond.
Yes.
Okay. So, Officer Brelo, in his statement, indicated that knowing his Marine Corps training always teach you to elevate if the target is threatening. But in my training, you were supposed to push through the target. So Officer Brelo indicated through his military training that was a military move.
Can I have the page number, please?
54. Wouldn't that be his perception? That he did a military move, moving up, pushing through the target?
No, sir, I disagree with that.
Okay, and sir, you would agree with me that the police are not at war with their citizens, correct?
That's correct.
Okay. And sir, you would agree with me too, and I think you even mentioned it in your report, that you don't want to speculate as an expert, correct?
I try not to.
You even said that in your report.
Correct.
Sir, I want to guide you or get you to page 26 of your report. Specifically 1.24. Are you there, sir?
Yes.
In 1.24, you state forensic acoustic evidence supports Officer Brelo's belief of deadly force threat. So basically what you said in that particular section is that based upon the ballistic reports from your experts, that Officer Brelo would have perceived shots coming out of the Malibu, correct?
Yes.
And sir, in that conclusion, how you get to that conclusion, you say if the three inconclusive shots, you call them shots, correct?
Yes.
And that is a fact in contention, is it not?
I believe both sides are not in agreement with that.
Right. Your experts say they're shots. Our experts say could be echoes. We don't know. Would that be a fair statement?
Objection.
Well, I heard the evidence. Overruled.
Yes,
It's in contention.
I agree.
But you rely on your expert for the conclusion. You say if the 3 inconclusive shots on the dash cam are discharges, then Brelo would have been in an elevated shooter position when these shots were discharged. Isn't that what you say?
I do.
And then you say, if Officer Brelo perceived those gunshots were coming from the suspect inside the Malibu, it would have been objectively reasonable for him to have responded with deadly force. Correct?
Correct.
Sir, you are speculating on getting to your conclusion. You say, if this happens, if my experts are correct, then that's what Officer Brelo perceived. Isn't that what you're saying, sir?
It is not what I'm saying.
You are speculating, sir, are you not?
I am not speculating.
Yes, you are, sir, because you don't know what Officer Brelo was perceiving there. You're trying to tell this court that Officer Brelo perceived shots coming out of the Malibu based upon one of your team experts. Isn't that correct, sir?
You're a pretty emotional fellow, aren't you? Listen,
Sir,
I'm going to
sir,
do you.
are you
I'm
talking
gonna-
Hold on, actually both of you, but Mr. Gutierrez, this is a thing that can occur with the style of cross. I'm not faulting you for it, but please don't interrupt the witness, and I will trust that Dr. Martinelli, that you will not interrupt him. But Mr. Gutierrez, I can read, and it says, if Officer Brelo perceived, etc. So, put aside, though, the emotional fellow business. Do you have a next question?
Yes. So, sir, you disagree with me that is speculation.
I do.
So you want this court to believe that if those things happen, then that's what you perceive.
Sir,
Yes or no, sir?
Yes.
Thank you. Now, sir, let's talk about tactics for a minute, okay? You teach tactics, right?
I do.
All right. And, sir, we can agree, and I think you said this in your direct examination, that violation of policy and procedures is not necessarily criminal. Do you agree with me on that?
I do.
And, in fact, violating police tactics is not necessarily criminal. We can agree on that, too, right?
Yes, sir.
And, in fact, you attack Mr. Caceres because he utilizes a violation of tactics to get to his conclusion of reasonableness. You agree with that one?
I do.
Okay. So, sir, you have written many articles, have you not?
I have.
Read copies. Sir, I'm going to cite you to an article that you wrote calling Art of Force Pre-Contact Threat Assessment. Remember that article, sir, that you wrote?
I do. I wrote it.
That's right. And in it you say distance and cover are your friends. Right?
They can be.
And you say whenever possible, utilize and maintain distance and cover from any resistant and potentially violent subject you intend to arrest. Correct?
Correct.
Distance allows you to observe more and prevents visual distortions such as perceptual narrowing or tunnel vision. So far, correct?
Correct.
Distance also enhances hearing, situational awareness, and lengthens reactionary gap. Correct?
Correct.
These benefits allow the involved officers to maintain center and balance, as well as working to mitigate or lessen potential for the officers to become emotionally captured in the event. Correct?
Correct.
So, by that paragraph and logic then, when Officer Brelo got here behind the trunk, according to you, he should have kept his distance from here. Correct?
Did you read the paragraph?
Sir, I'm asking you the question.
You don't understand the paragraph, sir. I'll answer the question.
Sir, I'm asking you, based upon that paragraph, Officer Brelo should have kept his distance.
Objection, Your Honor. May I have a copy of this article that you're referring to?
Hold on. The question might be better phrased based upon what I just read, because I sense the witness is saying there's more to the paragraph. So it would be more accurate to say, based upon what I read, can you agree to such and such a proposition?
Okay.
Just might avoid an argument with the witness.
Right. So, sir, my question is yes or no. You're talking about situational awareness and distance. Distance is your friend. Officer Brelo did not do that. In fact, he closed the distance that he had, did he not?
Sir, I don't disagree with that.
Okay.
I disagree with your premise on what I said in the article.
Okay. Well, again, Mr. D'Angelo will have an opportunity to redirect you, and then you can explain yourself. But distance and cover are your friends. That's what you wrote, right?
I did.
And sir, then you wrote an article to chase or not to chase, correct?
I did.
And we're talking about, in this article, the context is actually a foot chase, right? Talking about foot chases?
It is.
Okay? Right? And you say in here, police officers must balance their obligation to enforce laws and arrest perpetrators with their personal safety. Agree with that one?
I do.
Okay? Unfortunately, this rarely happens. More often than not, officers become emotionally captured in the event and have instinctive reaction rather than a studied and planned response to resistance and chase. Correct?
Yes.
So we're talking about a situation here where there's a foot chase. Is that the context of that article, sir?
It is.
And we can analogize that to this particular situation, can we not? Don't those principles apply in this situation too? Some of them?
Some of them, but not all the important ones.
Okay. Officers become emotionally captured in the event and have instinctive reaction. Isn't that what happened to Officer Brelo right here? Oh.
I disagree with you.
Okay. So he did not become emotionally captured in the event and have an instinctive response.
He had an instinctive response.
Well, I'm asking you, did he become emotionally captured and have an instinctive reaction?
Define emotional capture in this particular circumstance so I can help you.
Well, sir, so you're telling me, based upon what you think emotion captured is, Officer Brelo wasn't at that point.
From everything that I have read, Officer Brelo, as the other officers have indicated, were in intense fear of their lives.
So you're not answering my question.
I think I have.
I can agree with you, sir, that all the officers expressed a fear when they were there. Agree with me on that?
I do.
And sir, isn't it a fact that this is where their training is supposed to come in? When they're fearful in a situation, isn't that when their training is supposed to kick in, sir?
Sometimes yes and sometimes no.
But don't you want it to kick in at that point?
I think idealistically, yes.
Sir, isn't that why you train police officers? That when they are under stressful situations, that they react a certain way for the safety of themselves and everybody else around them?
I try to teach officers in...
Sir, it's yes or no?
I'm sorry. The answer would be yes, sir.
Thank you. Thank you. So you would agree with me that training is important?
I would.
Okay. Now, sir, I want to get you to page number 28 of your report. Are you with me there, sir?
Yes, sir.
Okay. You make a lot of conclusions on this page, do you not, sir?
We'll have some findings and opinions on that page.
Okay. And 1.31. Okay, you with me there?
I am.
And these are your words, sir, not mine. Okay? As an experienced officer, safety tactics, and firearms instructor and expert, I agree that it is proven that Officer Brelo moved from an elevated position of tactical advantage above the rear trunk of the police unit. Okay, we're talking him going up right now, right? Correct? Is that what
Yes.
you're saying? Right? From here to here. Okay? Are you also going from here to here also?
Well, you've separated. Actually, the move that 1.31 discusses is that first move I didn't necessarily have a problem with, and I talked with you about that yesterday, and I think I explained all my reasons for that.
Okay, so you have no problem him going up on the trunk?
No, for the reasons that I explained yesterday.
Okay, but in this particular paragraph, what movement are you talking about? Up on the trunk or to the hood?
To the hood.
Thank you. And then you say, sir, over to and onto the hood of the suspect vehicle where the perceived suspect shooters were located. Then his tactical decision was faulty and would be inconsistent with officer safety doctrine and training. Isn't that what you said, sir?
I did.
And you stand by those words?
I do.
So, Officer Brelo, by going from here to here, in your opinion, violated all sorts of tactical training and decisions that an officer should make.
He didn't violate all sorts of them. He violated basically one officer safety concept,
Okay.
and that was he left one position and exposed himself more than retraining.
He could have got shot by crossfire,
He
right?
could have.
And if the suspects were not incapacitated, the car could have kept on going. He could have got run over too, right?
I think there's a lot of variables there.
Right. All dangerous to Officer Brelo.
I wouldn't disagree with that.
And then you say, I do not see his actions as forming specific intent to murder or attempt to murder the suspect, which is a central element of those criminal offenses. Did you not say that, sir?
They're in my report. Of course I did.
Okay. Sir, are you a lawyer?
I'm not a lawyer.
Okay. And isn't it a fact, sir, in the beginning of your report, you stated experts like yourself should not give legal opinions? Did you not say that, sir?
I did.
And you just gave a legal opinion, did you not, sir? You just opined on his specific intent, did you not?
Okay.
Then the next paragraph. You say, rather, under the undeniability, intensely stressful circumstances of the encounter, I view Officer Brelo's mindset as being consistent with those of an officer whose mental state was increasingly potentiated by a perceived life threat to himself and his fellow officers. Right?
Yes.
Then you say, it is my opinion to a degree of medical, scientific, and professional certainty. I want to stop right there, sir. You are not a doctor, correct?
No, sir. I don't need to be a doctor to understand medical concepts. It's not a diagnosis.
Sir, I want to show you, you give me cases for them and for the court. State versus Johnson and MH County versus Almeida. Can I get copies to the court and to the defense?
Are these among the cases that you listed in his documents review?
I don't even know, to be honest with you, Judge.
I just wondered if that was the focus.
Did you give it to me? Okay, State versus Johnson, State versus no. And so you familiar with those cases?
No.
Can we get one for the witness, please?
Well, let's see what he's going to do. What, do you have him read a case? I hear him.
No, Judge, it goes to his opinions. Judge, in fact, a district court did not let him testify to the things that he's testifying to, Judge. And this goes right to his credibility as an expert to opine on all of these psychological and medical things that he has. I think it's right goes to the point of his qualifications, what he's telling this court right now.
Well, he's already been allowed to testify. You're actually the one eliciting these so-called medical opinions. I think I sustained an objection yesterday, especially to the stuff that Posey has an opinion about. So he's already testified, but he hasn't testified, in my mind, as a medical expert. He's testified as, to use a colloquial term, a use of force expert.
Well, Judge, again, if you read this case, it's exactly the same, and I don't know how to phrase, his psychological theories, Judge, because this court says explicitly he's not a psychologist. He doesn't have a medical degree. In fact, it says he has a bachelor's degree in exercise physiology. He has no degrees in medicine.
Hold on. May I interrupt you?
Sure.
And I'm sorry to do so. If you're going to move to strike his testimony, then I suppose you should do so at the appropriate time. Or if you're going to do so now, then finish the direct, because I'm not going to roll on this right now. I believe he's qualified to testify to almost everything he said. Some of the things that he tried to say, you'll recall I sustained some objections yesterday. So I'm not sure what this is, but if you want to impeach him by saying basically, weren't you disqualified in a case, I think that's okay. But if you're moving to strike the testimony already given and to prevent any further testimony, I'm not going to do that right now. I consider striking it later, but let's conclude the testimony itself.
Your Honor, may I indicate that there was no motion to limit the file date?
Well, you can object without filing a motion to limit. I mean, he's either qualified or not. You don't have to. You don't waive the ability to object based on qualifications by not filing a motion to limit. But to the point, it would have been better to have raised this issue before, so we could have had some sort of resolution. But if you want to ask him,
examination, Judge. But
you're telling me that I should exclude his testimony. I'm telling you, you're welcome to say basically, weren't you disqualified? Right. But the legal issue, that's for arguments by the lawyers and with the court's involvement. It's really not for the witness.
Judge, I did not ask the court to strike his testimony.
Yes, you just told me for 5 minutes how unqualified he was to testify to the things he's testified
to show this court that basically doesn't know what he's talking about, Judge. This is impeachment. This is impeachment.
Hold on. Please. He's certainly allowed to impeach. So, but let's get to the impeachment. Let's not have all this legal argument in the middle of a witness's testimony. I understand that my schedule has been sort of choppy this week, and I apologize for that. But this is another way a trial gets delayed, is by raising these things at a time when they're not supposed to be raised. So the next question is.
Thank you. Sir, MH versus County of Alameda, United States District Court for the Northern District of California. You remember that case, sir?
What was the name of the case?
You have a, don't you
Is this Johnson? No, you handed me Johnson.
I'm sorry. We'll get to Johnson in a minute.
Have you refreshed your recollection about that case?
Well, first of all, Your Honor, I wasn't aware that any motion had been filed, but I am aware of the case, sir.
Okay, so you're aware of the facts of your involvement, or your recollection's refreshed on that?
That is correct, sir.
And if he asks you, well, then please just give answers to whatever questions he has.
Sure.
So, sir, you were retained as an expert in that case?
I was.
Which side?
I was defending the County of Alameda.
Okay. Was that a civil or criminal action?
It's a civil action.
Okay. And sir, you offered an opinion in that case as an expert?
Yes,
And the court rejected that opinion, did it not?
apparently.
Well, the court said plaintiff's objection to Dr. Martinelli's qualifications is well taken. He is not a medical doctor. Although he described as an undergraduate major as pre-med, he received a bachelor's degree in exercise physiology. Everything's correct so far, right?
Correct.
He has no degrees in medicine, right?
Correct.
He has no medical licenses.
Correct.
He is not a psychologist.
Correct.
And today, and yesterday, I should say yesterday, you opined on the psychological variables and mindset of Officer Brelo at the time of this particular incident. Isn't that correct?
I'm opining on the information and evidence I have that indicates what the officers stated at the time.
It's yes or no, sir. If you, it's yes or no.
Yes, I have opined on that.
Thank you. And sir, that's cases, if you look, and for the record, Your Honor, it's 2015 U.S. District Lexus 12081, just for the record. So that's in 2015 February. This just happened, correct?
Apparently, I'm not aware of it.
You're not aware of the fact that your opinions were knocked out of this case?
Experts are.
Well, that does not surprise me, I'll tell you that, if that's intended for the fact finder. But you can ask him that. Well, actually, don't ask me again. He said he's not aware.
So the first time you became aware was when I asked you questions about it this morning.
That's correct.
Okay. You familiar with State v. Johnson?
Yes, I found out about State v. Johnson about 4 months ago.
Okay. And similarly, your opinions were not admitted into that particular case also, correct?
That's correct.
In fact, the court, and this court is the same court, it's the United States District Court for the District of Nevada, so in a different court now. And this was December 13, 2013. For the record, Your Honor, it's 2013 U.S. District Lexus 174854. And in that, the court opined, according to the defendant, Dr. Martinelli will testify as to whether the force used by the defendant was reasonable and how the mind works during and after stressful situations, and how gaps in remembering exact details can occur based upon the subtleness of the situation. Sir,
Objection, Your Honor.
isn't that what you're doing right now?
Hold on. Overruled.
I mean, the federal rule differs from the Ohio rule.
Here, this will come up on, just please, we got to get through this witness and the next, and the next, and the next.
Sir, that's what you're doing right now, correct?
Yes.
In this testimony at the arbitration, so this was a civil case, again.
It's correct. An officer was being prosecuted for excessive force.
And you were defending the officer.
I was.
Dr. Martinelli essentially walked through the video of the incident describing his perception of what happened. Nothing in his testimony indicated he possessed any specialized knowledge that would be necessary and helpful to the jury. The jury may view the video evidence and conduct its own evaluation of the sequence of events, including whether or not the defendant's conduct was objectively reasonable. Do you remember this?
Correct, sir. This was in regards to looking at a video and determining whether the suspect that the officer was handling at the time was resisting arrest. It had nothing to do with a determination of any psychological issues. It was a determination of what could be seen on the video and how the officer would perceive the movements of the suspect as being resistive. And I might also say that the attorney, that was the defendant's attorney, never responded to this motion, and the motion was granted. So he never defended, or he never opposed the motion. He didn't do anything. The motion was granted.
Are you done?
I am, sir.
Okay, that was a yes or no question. Just ask you yes or no, sir. If you don't understand, I'll rephrase.
I'm sorry, sir. Not every question that you asked me is a yes or no response.
And remember yesterday I said if you couldn't do that, you could tell me. I can't answer yes or no. Remember me asking you to do that?
Yes.
Thank you. Likewise, the court agrees that Dr. Martinelli's opinions about the defendant's memory would not be helpful to the jurors understand the facts at issue. Testimony that individuals may misremember things that occur in a stressful situation is within the realm of a juror's common sense knowledge. His testimony would not be helpful to jurors' understanding of the facts at issue. That is, whether the defendant misremembered the events or outright lied. Remember this?
Well, I'm remembering it now because this is the first time that I've ever seen it. I was advised as what happened in regards to this motion 4 months ago.
So this case and the other case that I mentioned to you, the Almeida case, were not on your CV. You didn't list, remember all the cases you listed? I'm sorry, not on your CV, but on all the things that, all those cases you said you reviewed for your opinion. Correct?
No, why would they be? They had nothing to do with the fact pattern of this case.
Okay. And sir, what the court basically said was that jurors can deduct what happens when people are under stress commonsensically. Isn't that what the court said in so many words? Yes or no, sir? If you disagree with me, say you disagree.
No, if it's in writing, I can't disagree with you.
But that is whether the defendant misremembered the events or outright lied. Remember that?
I do remember that.
Okay.
I don't make credibility determinations as an expert.
Okay, but in this case, you did. Did you not?
No, sir, I don't make credibility determinations. I look at circumstances.
Again, it's yes or no.
Are you asking for a response, or are you saying answer yes or no
I'm
to
asking
preface?
yes or no, sir. That's all I'm asking.
Okay, then just to help me help you, if you ask me a question, would you preface your comments by saying, sir, could you respond yes or no? And I'll be able to do that. And if I don't believe that I can respond yes or no, then I'll just tell you that.
Fantastic. Okay. Sir, in this case, did you not opine that Officer Brelo's memory lapse of him being on the hood was, in your words, how should I say, predictable, and it happens?
It is both yes. The answer is yes.
Okay, so you bolstered or corroborated, backed up Officer Brelo's statement that he doesn't remember what happened when he was on the hood. Right?
Well, I can't answer that yes or no, sir. Okay.
Did you not, and I believe it's in your report, sir, memory loss, page 37, 4.12.
Yes, sir, I've read it.
Did you not opine that the memory loss by Officer Brelo, because of the stressful event, happened?
Well, the officer states it happened.
Okay. And sir, you took that on face value.
Sir, I take every circumstance, statement, fact, and item of evidence on face value. I don't make a determination of whether someone is telling the truth or not telling the truth. I put down in my report that he represented that he did not have a memory of that. And I put that in my report.
And you backed it up.
I said in my report, and let me read from my report.
So did you back it up? I'm not asking you to read from your report. Did you back the fact up that his amnesia happened? And tell this court that under stressful situations, amnesia happens, and because it happened to Brelo in this situation, then it happened.
Objection.
Sir,
The word amnesia is not in that.
The witness,
Okay, memory loss. I'm
the
sorry,
witness
memory
is
loss.
capable of detecting whether his words are or not.
Memory loss.
Sir, I think it's probably best that I just read this paragraph that you're referring to so that we're clear on the record of what I'm saying.
Sure.
Officer
No, I'm
Brelo's...
not asking.
Hold on, Mr. Gutierrez, hold on. How about this?
Yes, sir.
If you agree with a proposition, with every word of his proposition, say I agree. If you disagree with a single word of his proposition, say I disagree.
Thank you for the direction, Your Honor. I appreciate
And
it.
it'll go quickly.
Thank you, sir. I disagree with you, sir.
Okay. But you just said a minute ago that you take on face value, you don't determine veracity or truthfulness in your determinations of your ultimate conclusions when you review cases.
That's correct, sir. I don't make credibility determinations.
Sir, and again, and I'm not trying to fault you because there's some pretty big case, a lot of facts. You'd agree with me on this, right?
I'm sorry, there's some what?
A lot of facts in this case.
Yes, sir, there are.
And yesterday I asked you some facts and you weren't sure on them because there is a lot of facts. Correct? For example, you didn't know that Officer Brelo stated that he jammed his first magazine in his car, according to his statement. Remember, you didn't remember that?
I don't know if I said I didn't remember that, but I will agree with you. There's been a couple of facts in this case with regards to the C-clamp on the door, and a couple of things like that that I did either not know or did not recall.
Okay. So did you review Officer Sobolik's statement?
I did.
And in Officer Sobolik's statement, did he not say that Officer Brelo told him he was on the hook?
Officer Sobolik stated that Officer Brelo was on the hook. Yes.
Did you read Lieutenant Ketterer's statement?
Objection, Your Honor.
Well, first of all, you went on from the proposition that you wanted him to agree to that he didn't exactly agree to. But second, the objection, did you read Ketterer's? Overruled.
Well, let's go back to Sobolik said he was on the hook,
Objection.
Overruled.
right?
Yes.
And Officer Brelo had a conversation with Lieutenant Ketterer, told him he was on the hook.
Yes.
Okay? But you ignored those facts to get to your conclusion that his memory loss was okay, without at all considering whether he was not telling the truth. Correct?
I disagree with your premise of what I'm stating in my report, sir.
I must misspoke. Officer Brelo told Officer Sobolik he was on the hook. Do you remember that in Officer Sobolik's statement? Because obviously I misspoke.
I have to say I don't recall that.
You don't recall that.
I'm sorry.
Okay. Sir, so you don't recall whether Officer Sobolik stated that or not? That's your testimony?
Right at this time, I don't recall that, sir.
And Lieutenant Ketterer stated that Officer Brelo told him that he was on the hook.
Objection, Your Honor.
I recall that statement.
But just like the other facts that you conveniently left out, we talked about the perceptions of the officers during the chase, you also conveniently just disregarded those particular facts to make your conclusion that his memory loss was consistent with people who were in high-stress situations. Correct?
I disagree with you, sir.
But you left those facts out, did you not?
I disagree with you, sir.
You didn't put those facts in your report, did you? Did you report that Sobolik was told by Officer Brelo that he was on the hook? Did you put that in your report?
That is not in my report.
And did you report that Lieutenant Ketterer told him? I'm sorry, that's Officer Brelo told Officer Ketterer he was on the hook. That's not in your report either.
No, sir. My report reflects that Officer Brelo was on the hood of the car and that he did not recall that he was on the hood of the car.
And you bolstered that statement by saying that's okay, because when we're in high-stress situations, things like that happen. Endorphins, all those chemicals, remember that? Right?
Well, you're asking me several questions, sir. Would you like to separate the questions so that I can respond to them?
Sure. All right. You did not feel it was relevant to put those facts in your report,
That
right?
is not correct, sir.
Okay. But you, again, I don't want to belabor, you just didn't put him in there. For whatever reason. Correct?
Those facts are not in the report.
Sir, on page 28, and we're on page 28, 1.31, we talked about the tactical and faulty decisions that be inconsistent with officer safety. Remember that?
Yes, sir.
Okay. And then the next paragraph down. I view Officer Breleau's mindset as being consistent with those of an officer whose mental state was increasingly potentiated by a perceived life threat to himself and his fellow officers. So, sir, what you're saying is you're going into Officer Brelo's mind based upon your review of everything and saying that he was scared.
No, sir. There's ample evidence in the discovery that Officer Brelo has stated consistently that he was scared, afraid, and terrified of being killed, being shot, and having other officers that were at the scene being shot and killed.
Sir,
so that is not me going into Officer Brelo's mind. I'm not a mind reader. I put down what the forensic facts are in this case, and there's ample evidence. As a matter of fact, on the following page of my report, I think I list, or one of these pages, I list an entire page of all of his statements.
Did I ask you all that you just blurted out?
Well, Mr. Gutierrez, it's not a sophisticated cross-examination technique.
Thank you, Your Honor. Sir, do you fancy yourself as a scientist?
As a scientist? No.
But you put down to a reasonable degree of scientific certainty, did you not?
As a forensic criminologist, sir, I use applied sciences in my determinations in order to investigate and analyze.
Sir, and you're not a medical, you have no medical degrees or licenses, correct?
No, sir. I know how to read medical journals. I know how to read medical reports that are consistent with what I need to form findings and opinions.
Sir,
I am a forensic expert.
You're not a medical expert.
I don't need to be a medical expert.
Sir,
I need to be able to... Okay, I'm not going to argue with you. I'll just be quiet.
I asked you a question. Are you a medical expert? Yes or no?
It depends on what areas of medicine. Yes, I'm not a doctor. I've been judged to be a subject matter expert before in psychomedical emergencies and some issues of mental health. I don't put myself out as a doctor. I'm a PhD.
In what?
In criminology with emphasis in forensic psychology.
But two district courts told you you can't opine on your medical conclusions, but you want to come in here in Ohio and tell this court that you have this medical background because you, what, read all these medical journals? It's yes or no, sir?
I'm sorry, I disagree with you. I can't answer a yes or no to that statement.
Sir, do you remember Mr. D'Angelo asking you that your opinions were to a professional degree of reasonable certainty? Remember that?
I do, sir.
He did not say medical or scientific because you're not a scientist and you're not a doctor. Isn't that right?
Sir?
Well, hold on. It's getting redundant. He has agreed he's not a scientist. He's agreed he's not a doctor. Why do I need to hear that 5, 6, 7, 8 times?
You don't, Your Honor.
Well, but you brought it up 5, 6, 7, 8 times.
Sir, let's move on to page 31. You opine, do you not, that it was Timothy Russell's and Malissa Williams' fault for them being killed?
What I've stated is that the law required them to stop, and they committed crimes in continuing this event, which ultimately led to their deaths.
So it was their fault?
I have opined that... I'm sorry.
Go ahead.
I have opined that if they had not fled from the police, then the subsequent series of events would not have taken place, and they would not be dead today.
So it's their fault that Officer Nan mistook a backfire for a gunshot?
Objection.
Overruled.
I would say that it's not their fault that that took place.
Sir, I want to go back before I get into this other issue, and I missed it. On page 28 and 29, you say that Officer Brelo's focused self-preservation mindset. Are you with me there, sir?
Yes, sir.
Okay. In the fog of an intense, unique officer-involved shooting engagement. So far, right?
Yes.
Okay. So what you're saying is Officer Brelo was scared for his life at that point.
Which is what he repeatedly expressed.
But that's what you're saying, right?
I'm repeating my understanding of what the officer has stated in his interview statements.
But you're saying that fear compelled him to eliminate the threat.
I have.
Okay? So what you're saying is, anytime an officer fears that he's going to get killed, he doesn't have to act reasonably. Is that what you're saying, sir?
I'm sorry, I didn't read that in my report. Is that in there where you can show me that?
I'm asking you, is that what you're saying, sir?
I'm not saying that at all, Counselor.
I just asked you that question. Do you remember, sir, writing an article? You have a copy for the question?
Got an extra. Got one. An extra.
I probably don't need it right now. He may need to have his recollection refreshed.
Sir, when you just opined on page 29 and 30 about his fear was so great that he needed to eliminate, compelled to eliminate the threat, are you saying he was hypervigilant?
I'm saying there could have been an aspect of hypervigilance there. I believe I've said it in my report.
Okay, an aspect of hypervigilance. But I'm asking you, was he hypervigilant?
I don't
In your
know.
opinion.
I don't know if he was hypervigilant.
Okay. So did you not write that I found a clear nexus between a lack of appropriate force training, officers' maturity, and situational awareness with the occasional tragic consequences of accidental and excessively applied force? Did you not say that regarding the BART shootings?
It's a different fact pattern. I did. First of all, the answer to your question is yes.
Okay, so in that fact pattern, there was a scuffle on top of a BART station, correct?
Yes, sir.
And the officers had the guy down, right, trying to handcuff him, and he resisted.
One police officer had the suspect down and was attempting to restrain
And the crowd was coming around, right? Other officers moved up, and there was kind of a tense situation, correct?
Yes, sir.
And then the officer took out his gun when the guy was on the ground, shot him right in the back.
No. The
Right.
fact pattern was yes, but he thought he was taking out a taser
Well,
issue.
that's what he said later. But that was in contention too, was it not? He didn't say that at the scene. Did he not, sir?
If
Facts
you,
are pretty evident that at the scene, when he was talking to his field officer, he did not say that.
sir, that's not a yes or no answer. I can explain
Okay, well,
the fact pattern very briefly.
we're talking about people versus Michelle, M-E-H-S-E-R-L-E. Okay, that was the victim, oh, I'm sorry, that was a police officer in the case, right?
His name is Meserly, sir.
How do you pronounce it?
Meserly.
Thank you. I was way off, wasn't
Yes, you were.
I? Okay. And here it lays out the fact pattern. All right? It says right here, shortly after the shooting, the defendant talked to Perone on the platform. Said, I thought he was going for a gun. The minutes after the shooting, he had several conversations on the platform with Perone, spelled P-I-R-O-N-E, and 3 other officers, and said nothing about mistaking his handgun for a taser. I'm sorry. That's in the reported Court of Appeals of California, and it's reported as 2206 Cal App 4th, 1125. Okay?
That is an incomplete fact pattern, sir.
So the Court of Appeals was not correct when they resuscitated their effects.
Now, what you're talking about in that particular item, which is one single fact, that is not the totality of the fact pattern. And there is forensic video evidence and audio evidence that when the officer, that first of all, the suspect on the ground had his arms underneath his body, and the officer expressed a reasonable belief that the subject may be armed. He, trying to restrain him, he pulled out his taser and yelled, "Taser, taser," and what turned out is instead of pulling out his taser, he pulled out his handgun and shot the suspect once in the back and then yelled, "Oh my God."
And he was convicted, was he not?
He was convicted.
And so the Court of Appeals version of the facts don't jive with your version.
I'm not going to...
Overrule, but why are we litigating this case?
Right.
Okay. Sir, did you not write, if an officer lacks sufficient training or has been properly trained in critical force and weapon skill sets, there will be no correct force or weapon deployment memory for the brain to access?
That's correct.
Okay.
In that case.
And you say in such situations also may easily present with hypervigilance and react with confusion and irrational acts. Did you not say that?
I did.
And sir, isn't that exactly what Officer Brelo did right here? He was in a hypervigilant state. His emotions overcame him. He did not follow his training and went to a position that was tactically incorrect and not reasoned. Do you agree with that or not?
No, sir, I do not agree with your entire premise on that.
And sir, did you say also today in our superficial and indulgent society, people are more inclined to accept blame and accept responsibility for their actions?
I have said that.
Okay. Sir, let me ask you this. When was the last time that you testified on behalf of the state in the prosecution of a police officer in front of a jury saying that his force was not reasonable?
I do not, in a criminal case?
Yes.
Well, I've done many civil cases in that fact. In a criminal case, I don't recall. I did have a self-defense case where I provided the district attorney's office in Riverside County with appropriate consultation so that they could proceed with the prosecution of a deputy sheriff who had shot an individual. No, they didn't need me to testify. They desired my consultation. I'm sorry.
I'm just asking you to testify. When was the last time that you testified? You said you couldn't recall.
No, I'd have to look at my case history, but offhand, I don't recall right now.
So, not this year, obviously.
No, sir.
Not last year.
No.
And sir, isn't it a fact that the majority of times that you are consulted and testify in criminal cases, you're always saying that the officer in charge here that you're consulting with was reasonable?
Well, hold on, because you said the majority, but you're always. So it's either always or a majority, but it really can't be both. How is he going to say yes to that? Or for that matter, no?
Okay, I'll rephrase you, Ron. Sir, you can't remember the last time you testified in a criminal case with the prosecution?
That's correct. Prosecutors usually use detectives as their experts in the prosecution of officers.
Sir, didn't you in the Barr case in this particular article come to the conclusion that it was the decedent's fault that he got killed?
No, sir. I came to the conclusion that the officer mistook his taser for a handgun in a very stressful situation.
Well, vice versa. He took the handgun for a taser.
I'm sorry. That's correct. He mistook his handgun for a taser. That was the purpose of writing that article. How can something like that happen where an officer is charged with homicide?
Did you not say Grant should not have been, Grant is the decedent, should not have been involved in any type of disturbance that day? And he certainly should have been compliant and cooperative when contacted by uniformed Barr officers. Are you not assessing blame for his actions too?
The suspect in this case that became the decedent committed a criminal act. My point in writing that paragraph is basically that could have been avoided had the suspect in the case not resisted the police.
So, in this case, you also placed blame on Timothy Russell and Miss Williams. So what you're saying, sir, in essence is comply or die.
Sir, I'm not saying that at all. I'm saying that exactly what I said in my report. This case, this incident could have been avoided had not approximately 7 felonies prior to the ultimate shooting had been committed.
Sir, you say if he had comported himself in this manner, he would be alive today.
That's absolutely correct.
So if Timothy Russell, and he was the driver, not Melissa Williams, would have pulled over, he'd have been alive today.
That is my reasonable belief.
Right. And so, but what you're saying then is, if you don't comply, then you're going to die.
No, sir, I'm not going to say that. What I'm saying is that
answer the question. You said, no, sir, I'm not saying that. I don't need your explanation.
I disagree with your premise, sir.
All right.
We'll take a break. So you remain under oath. We'll be back in a few minutes.